First District Court of Appeal is now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, great state of Florida, and this honorable court.
Good afternoon. Please be seated. Welcome to the First District Court of Appeal. We have one case on the docket. It is Michael Glenn Trust versus Walton County. It's 240682. You may proceed when ready. Got 24 minutes per side. And the clerk tells me you've worked out your division, and you're responsible for keeping track of that. Okay.
Yeah, yes, Your Honor.
Okay. Then you may proceed.
Yes, Your Honor. I will be watching the time. I'm here. May it please the court. Excuse me. Good afternoon. Chance Lyman on behalf of Petitioner Bruce Healy. This is a consolidated appeal. I'm on behalf of Bruce Healy, and I'm going to be splitting my time with the co-petitioner in this case. Okay. So I'm just going to begin by addressing the focus order that the court issued. The court asks if there is still a cognizable harm that can be addressed. Yes, the answer is yes. It's the final judgment in this case. The repeal of the statute doesn't repeal the final judgment. If anything, our position is that the repeal of the statute should be beneficial to the petitioners under a pipeline analysis because it's a change in procedural law that should apply now under the East Coast Railroad case we cited in the reply brief. Put simply, Chapter 163.
So without 163.035, what does the declaration mean?
That's an excellent question. I think the declaration means what it purports to say, which is that it is affirming the public's right to use our property with these very specific uses.
Yeah, but without a statutory mechanism to make it effective, I'm wondering, is this like Michael Scott declaring bankruptcy? I mean, does it mean anything? I mean, I could stand out in my yard and yell, "I'm entitled to use my neighbor's pool," and he really couldn't do anything about it until I went into his yard and tried to use his pool.
And that's it. We already argued that this judgment was void for lack of subject matter jurisdiction, so that same level of voidness, for lack of a better word, really is just reinforced by the repeal of the statute. I see it as, if anything, it's mooting the opposition arguments. It's not mooting the basis that we're seeking reversal here. For example, Chapter 163.035 created this intervention by a party defendant to sort of cure what the subject matter jurisdiction problem was from the beginning. That procedure has been repealed, so it shouldn't be applied. It shouldn't be able to be a basis to now affirm the judgment on appeal. And if anything, again, it never cured the subject matter jurisdiction problem in the first place. So for that reason, this judgment purports to do something that the court does not have judicial power to do. And that's why we've requested that this court use its appellate jurisdiction to reverse or quash the final judgment on appeal.
Could the legislature, let's assume that the statute hadn't been repealed, just take 163.035 for what it is, but instead of tasking the trial court with doing the affirming of customary use as a condition preceding to the ordinance going into effect, it tasks like the Department of Commerce or the Community Affairs Department with making an assessment or a certification of customary use, and after the executive branch or an executive branch agency made that certification, then the ordinance can go into effect. Could the legislature do that?
Create an agency mechanism by which...
Well, yeah, instead of having the court make this determination or whatever it is, just have the executive branch make a certification about customary use as a condition precedent, and then they can do the whole, and if you have a dispute of fact as how the agency did its job, you can always get an ALJ to make a determination. You can do the usual 12057 route. Could the legislature have done that instead? I
think to the extent that it's considered a quasi-legislative power, then yes, this particular judgment reads like a piece of legislation. It does not do what a court judgment should. So I think that under no circumstances could the judicial power be used to do what this final judgment does, because I think
So
that's
it could have the executive power or an agency do like the certifying as a condition precedent to the ordinance going into effect. Like your ordinance cannot go into effect until you get the report, from an agency that says it's okay, whatever kind of thing.
fact-finding sort of
Yeah,
thing.
whatever.
I think that is possible because, again, it wouldn't present the same separation of powers problem that's going on right here.
Yeah.
And it's this Article 5 judicial power, separation of powers problem that is why this particular judgment.
So then that gets to the next question is, are there circumstances when the legislature could dragoon the judicial branch into doing some sort of administrative work? It may not be judicial power that they're exercising, but it might be something else. Let's say, could a trial court do something other than the exercise judicial power and have that not run afoul of the separation of powers?
I don't believe they could. The judicial power is reserved only for the courts.
But can
and
the courts only exercise judicial power, I guess?
I think they would violate Article 2, Section 3, if they exercised another power, another branch's power, without a constitutional.
The legislature does it all the time. I mean, we make county judges sit on canvassing boards, and that's clearly executive function.
Well, I think if there was a constitutional, blessing of that sharing of power, that's possible. But I don't think the legislature could do that without violating the constitutional separation of powers.
Yeah, well, yeah, I mean, seconding Judge Roberts' question, that's kind of where it's going. So, yeah, it's a trial judge by title is doing this certifying or whatever, but even if he's not exercising judicial power, and he's just a judge, but he's doing something more administrative, is that constitutionally problematic? Can you not have a member of one branch, so like a judge, operate in an administrative capacity doing something else?
Well, I think you could if there was a constitutional authorization for that, I think is my answer, because that would be acknowledging, the exception to the broad separation of powers. So we would start there and.
Because Article 2, Section 3 says, unless otherwise.
Exactly. And a canvassing board, I suppose, is a good example. I was trying to think of others, but, at here, we have a complaint that was triggered, under Section 163.035, but also Chapter 86. And that's, just to circle back to the justiciability issue, that's why we think that there's still a harm that's cognizable in this court that can be remedied. This court needs to vacate the exercise of judicial power that was without subject matter jurisdiction. That's our main point here.
What is the harm from an order that isn't actually an order, I guess?
Well, I mean, it sort of the walks like a duck, talks like a duck kind of harm. I mean, how else would anyone know that this judgment is of no legal force and effect if not from an order from this court saying so?
So when the landowners had people show up on their property, they could seek enforcement, file a trespass action against these people that were on their property, right?
Well, I think that would be an option, but I don't think that option removes this current appeal, like the cognizability of this court seeking, or being able to review this particular judgment and address that issue now.
Well, the 2017 ordinance stands now, right? So with the repeal of this statute, I mean, I'm trying to figure out what the effect of this judgment is, given the fact that we have now the 2017 ordinance that's still valid on the books, correct?
I don't know if necessarily the 2017 ordinance, it is still on the books. Mm-hmm. The county's complaint, though, in this case, pled that it was invalidated by Chapter 163.035, and so I've sort of looked through the lens of this final judgment with that pleading in mind. To the extent 163.05 now no longer exists, right. Does 2017 ordinance is revived? Well, I think my answer is the 2017 ordinance also does not declare customary use exists. I think it operates as a limit on a trespass power, and I'm just don't have
But with the repeal of the statute, I mean, aren't we back to square one where if someone tries to act on that ordinance, then there's a lawsuit, and then that litigation, continues until a resolution. So again, I'm struggling with what remedy, what we can do here, given the fact that the order below is almost a nullity,
Well,
or it could be
I
considered a
would,
nullity.
I really would agree that it is a nullity because the court never had jurisdiction to enter it. In terms of the 2017 ordinance, I think that would just be another litigation. That would be other litigation. I don't know that the fact that other litigation, sort of, as Judge Roberts just asked, I don't know that other litigation that we all think is coming is necessarily a reason that this court cannot provide any relief today as to this final judgment. And I mean, I suppose it would be separate legal issues, really, because that 2017 ordinance is not doing the same thing that this final judgment is doing. This final judgment is invoking the, common law doctrine of customary use to tell, these petitioners at least that the public can use their property, that they have lost the right of exclusion in their property rights. I'm at the time that I have agreed to split, so I will stop, and I think I did a good job watching that clock. Thank you.
Good afternoon, thank you. May it please the court, Kent Seifert with Holtzman Vogel on behalf of petitioners, appellates T. Michael Glenn Trust and Link Partners LLC. Just to follow up on the question, the order below eliminates the right to exclude of our clients. It takes that property right. They no longer have it as a result of that order, along with
How does that work?
82 other properties.
How does that work? I mean, walk us through, in real life, I mean, that's a statement of what the order says, but how does it actually take away?
That's
Your
correct.
client's
As one of the fundamental property rights in that bundle is the right to exclude. All of us that own property possesses that right. Currently at the beach, they have the right to exclude people from their property. This order finds, as a matter of customary use, to the extent it exists, prevents a landowner from exercising that right to exclude. So when they call the sheriff is going to come down there and say, well, here's the final judgment that says customary use is on this property. You don't have the right to exclude them anymore. They have the right to recreate as set forth in that final judgment. That's why that final judgment, to the extent it grants customary use rights, must be vacated by this court.
So your argument is, and you're probably working together, I'm assuming, have similar positions. So your claim of harm from this, quotes for now, this judgment or order of the court is a confusion or a concern that people are going to give it some sort of weight that it otherwise doesn't deserve unless we do something about it. Is that?
Well, right now, it's a valid final judgment that's recorded in the official records.
Well, I thought that that's one of your points, though, is that it's not a valid final
Well,
judgment. It's a nothing.
It appears to be. To the deputy on the scene, he's
Yeah.
going to
And
read
that's
it.
what I mean, right?
He's, normally if you have someone trespass on your property, you can call the sheriff's department and get them removed.
Correct.
But because of this judgment, whether it's valid or not, you're saying that won't happen.
That's right, and it's this court's job to say that judgment is invalid. The sheriff's not going to know that. The trial judge is not going to invalidate it on his own. It's valid until some other higher court says it's invalid.
But what about but even with the judgment vacated or reversed, you still got the ordinance. So isn't the sheriff going to say, yeah, but there's these ordinances?
Well, no, from a practical matter, the county has made representations to this court back in the oral argument we had in the Gibson case that ordinance has been vacated by the prior law. I think they're going to
I
have to.
remember having that conversation.
And I think they're gonna have to-
Still not understanding how the statute invalidates the ordinance, whatever their argument was.
Well, we think it did. The county said it did. They represented that in several courts. But from a practical standpoint, this litigation resolved all properties within Walton County, all 1,194. 83 of them are subject to this final judgment that found limited customary use. 63, I believe, entered into a settlement agreement. The rest of the properties were dismissed with prejudice, never have customary use on them ever again. So to the extent the county passes some kind of an ordinance to apply to those properties that have been dismissed with prejudice, there's going to obviously be some more lawsuits, and there's also going to be some takings claims for that. So from a practical standpoint here, what we're dealing with is we go back to the doctrine of customary use, and this takes us to subject matter jurisdiction. If customary use is substantive law, be it from the 1974 Tonorama decision, or be it from Chapter 163, whether it was substantive law there, although that's been repealed now, if it's substantive law, there can be subject matter jurisdiction to declare that customary use exists on property rights. But if it's not substantive law, no court has subject matter jurisdiction to declare customary use on anything because it's not substantive law. So that takes us all the way back to our constitutional arguments and our argument where first, the statement in the Tonorama case is dicta. The statement talking about the customary use doctrine, the four-part test, is dicta. That statement had nothing to do with the issue in that case, and we argued this at length on the last panel, because the issue in that case was the 230 square feet of the tower, where a tower was being built. The first HDA found that it was a prescriptive easement on it and ordered it to be removed. The Florida Supreme Court said, no, there's no prescriptive easement because there's no adversity. And so the tower can go up. But then the court went on to talk about the 15,000 square feet of dry sand beach outside of this tower foundation and said that customary use is this and that, and it's, and it come up with a four-part test that says if it's ancient, if it's reasonable, without interruption, free from dispute, such use as a matter of custom should not be interfered with by the owner. Gratuitous dicta. The trial court below in the final judgment said it was dicta, but also felt handcuffed by the 5th DCA case in the Trepanier that suggested it was substantive law. Now, even if this court doesn't find that it's dicta, and that's a case of a question of first impression, because no court has identified whether that statement is dicta or not. If you don't find that it's dicta, you got to look at the constitutionality of this doctrine. And what does this doctrine do? As I mentioned earlier, it takes away the property owner's right to exclude. And it's premised on the Florida Supreme Court, again, in its 1974 decision, created this judicial doctrine. And it's premised on English law. But in England, there was a 7-part test to establish custom. And custom there was a local law. It was not a common law. It does not apply to the public at large.
Let me ask you that, because your brief did a very good job of outlining those arguments, but do we need to even address whether customary use is a thing if we decide that there is no justiciable controversy because there was no adverse interest here? So go back to that part of your argument. There's no party on the other side of the V in the DEC action or under the statute, which is now repealed.
Right, and that argument gets to the procedural nature, I think, of the argument rather than substantive. So whether it's under a DEC action, whether it's under 163, whether the legislature, creates some other statute, the central question is customary use substantive law? If it's not, there's no jurisdiction to consider it. So it doesn't, so answering the question, there was no defendant named, doesn't answer the underlying question of subject matter jurisdiction as to whether, maybe we go back, they name a defendant, and the question's still there. Is there subject matter jurisdiction when they name a defendant and seek to establish customary use under the Tonorama decision?
Right, but they didn't name a defendant here. So the cart before the horse. I mean, you're encouraging us to address the heady constitutional issue, and I understand the reasons for doing that, but do we need to do that? Do we need to reach that issue if we determine there's no justiciable controversy because there was no adverse interest?
Yes, I believe actually you do, and I am asking you that, and I'm asking that this court for the third time to address this very issue. Both in the North Shore case, we tried to address it. The last case in Gibson, we tried to address
Wouldn't that kind of be an advisory opinion or even dicta? Because we're positing law that's not necessary to decide the case.
No, I think it is.
Or worse, ruling that the Florida Supreme Court was unconstitutional.
Well, or it was dicta, one or the other, and we can get to the constitutionality. I'm not asking you to overrule the Florida Supreme Court. There's been 4 U.S. Supreme Court cases since 1974 that renders that decision or that doctrine a taking under the Fifth Amendment. But back to your point, Judge Ray, yes, I'm asking you to answer that constitutional question. In the case of Sullivan versus Sapp, it's not cited in our brief, so I'll give you the cite. 866 Southern 2nd 28 addresses this very issue. It says, normally when courts, may be resolved on grounds other than constitutional, the court will ordinarily refrain from proceeding to decide the constitutional question. But then it says, in this case, the constitutional question is the basis for their jurisdiction. It dealt with the statute giving grandparents visitation rights. And recognizing that the parties have spent a lot in the litigation and the issue needed to be clarified, going forward for the parties. It's a really good case, and I don't have time to get into all of the details. But there it found, we're going to answer that constitutional question because it goes to our jurisdiction. And here, I think it goes to the jurisdiction. Because if you just dismiss it because there's not a defendant, well, there's going to be in Okaloosa County, Escambia County. All these other counties are going to name defendants, and they're going to be litigating customary use again. Well, the question in all of those cases is there subject matter jurisdiction? If customary use is not substantive law, it doesn't matter how many defendants they name. They don't have jurisdiction to declare customary use when customary use is something unconstitutional. And I need to reserve the remainder of our time for my colleague and I for rebuttal. All right, thank you.
So, Mr. Theriak, you're not splitting time.
No, sir.
Okay, good.
Good afternoon. My name is David Theriak. I represent Walton County. With me is co-counsel Glenn Burhan. As Mr. Seyfried correctly said, this is the third time we've been here arguing over customary use. And now that the legislature has repealed 163035, hopefully we won't be back for a fourth time, at least as it pertains to 163035. We start at a different spot with our argument. Before this court, we respectfully submit, even gets to the repeal of the statute language, we believe that this is an improper collateral attack on the final judgment, and that this court doesn't have jurisdiction to address what's pending before it. And our basis for that is it's undisputed that each petitioner that's before you received the statutory notice that 163035 required that the county provide. It's undisputed that the notice informed each petitioner about their right to intervene in the case. It's also undisputed that each petitioner could have moved to intervene under Rule 1.230, which many interveners used to become defendants in this case. And the petitioners decided to not intervene. They had a right to decide not to intervene. But having failed to intervene, we submit that the petitioners are precluded from bringing either an appeal or a petition for writ of certiorari.
What's your basis in law for that?
Bundy versus Tucker. And in Bondi, quote, with rare exception, failure to participate as a party in the lower tribunal precludes the ability to invoke appellate proceedings.
Yeah. And that's why we converted it to a cert petition, which is always available to everyone so they have access to the courts for the redress of harm. So if they're asserting that they are still suffering a harm by this judgment, I mean, it's a higher standard for them, but how do they not have access to this court if they can establish that they're suffering harm from this court?
Also, Bondi versus Tucker. It's an extraordinary remedy. And if there was a remedy available below that they failed to utilize, then they can't use the certiorari at the appellate
No,
court
the
level.
cert is available. You don't get cert with the appellate court if you had a route for direct appeal. And they didn't have a route for direct appeal because they weren't a party below.
And I would submit that the Bondi versus Tucker case, Your Honor, which is also a first DCA case, stated that because the Attorney General had the right to intervene, she had an adequate remedy below and could not use certiorari to bring the trial court's decision to the First District Court of Appeal. And that's what we have here. They had, all three of them, had an opportunity to intervene back in 2018, 2019. They sat for 5 years, did not exercise that right to intervene, and then literally after the summary judgment hearing and the court's order on the summary judgment hearing, that's the first time that the petitioners appear.
But Bondi v. Tucker involved an actual trial court proceeding below, right? It wasn't one of these in Ray kind of cases.
I would submit that we had an actual trial proceeding. We had about 500.
Well, I'm sure it resembled one, but it still has in Ray in the caption. So who's on the other side of the V in the case?
There wasn't. We followed the statutory process that the legislature dictated to us. As you
Which
may,
is no longer.
I'm sorry.
Which no longer exists.
Yes, you're absolutely right, Your Honor. As you may recall, the history of this case, we adopted an ordinance in 2016, became effective April 1, 2017. While several lawsuits were filed challenging that ordinance, some in federal court, some in state court, the Florida legislature adopted 163035. And let me pull it up, because I don't want to quote it incorrectly.
Do you still take the position you took with me last time we had OA, that the ordinance was repealed by the statute?
Yes. And that,
Is that no longer in, like, Muni code? Like, did the county actually get rid of that ordinance?
I haven't checked Muni code. What I know, Your Honor, is that when the legislature adopted 163035, they grandfathered ordinances in that were adopted prior to January 1, 2016. Ours was adopted after 2016. When the 11th Circuit basically vacated our home rule victory in federal court under the prior setup, not the 163 setup, we settled several other cases by admitting that this ordinance invalidated, the statute invalidated our ordinance. There were about 6 other cases that were at issue at that time. So the county, both in trial court at state level, trial court, federal level, and at the 11th Circuit and before the First District Court of Appeal, has consistently stated that we deem our ordinance, which was the target of 163035, to have been invalidated and not in effect at this point. And just to clarify,
Well, not being in effect is different than being invalidated. Not being in effect is actually what the statute says, that it won't be in effect until this process happens. Well, that process has now been eliminated. That policy has now been eliminated. If your ordinance is still on the books, why would your ordinance not just now be in effect?
I would submit, Your Honor, because of the representations that the county has consistently made in court cases, including settling court cases, by admitting that the ordinance is not valid, that it was invalidated by 163035. We would be taking a completely contrary position to what we have done since 18, if we were to make that argument. And
So what happens now from the county's perspective?
what happens now is it's almost like a Gilda Radner moment. We started off with home rule power. 163 gets adopted by the legislature. We go through this process we filed in 18. Here we are at 25. We've been doing this for 7 years under 163035, and then the Florida legislature says, never mind. We're going to repeal 163035, and I think that puts us back to where we were before 16335 was adopted, that the county has the home rule power to adopt an ordinance regulating customary use on the dry sand in Walton County that can meet the 4-part test of Tonorama. I would note that after this final judgment was entered, the county still has not taken the second step that was in 163035. This was a 2-prong approach that the legislature set forth. One, we had to file a complaint in circuit court, which we did. And after there's a judicial determination, the county can adopt an ordinance. We have not done that yet. So we have not actually adopted that second prong of 163035. The V question. When 163035 was adopted, it provided some uncertainty, to say the least, of how to proceed. When we looked at the statute, it appeared to set up a process that gave a property owner the right to decide whether he or she wanted to be a party. It allowed a property owner to decide whether to intervene. We perceived that to mean that we would name the parcels that we were seeking customary use in our complaint, which we do. All the parcel numbers are in the complaint. And we read that provision in the statute to mean that we're not supposed to name all the individual property owners, because then we would be compelling them to be a party when the statute is set up in a manner that allows them to make the determination if they want to be a party in this lawsuit. And as you can tell by the record, a lot of people didn't. They simply did not intervene. The final judgment addresses about 81, 82 parcels of beachfront property owners that did not move to intervene. And we were able to receive summary judgment that customary use factors in the criteria were established by the county.
Are you asserting that this is actually an in rem judgment of some sort? That because you said we don't want to make them parties, so we just name the properties, but actually the in re just talks about 1,000 properties or whatever,
Yeah.
without specifying. So is the action against the properties?
We viewed the action being against the properties by naming the properties, that we were seeking to establish the public's right to use the dry sand for customary recreational purposes on the parcels identified in the complaint.
So were the appellant's properties named or
Yes.
listed?
They were named.
So there is from your perspective, a judgment of some sort against their property.
Their property is included in the final judgment. There is a parcel ID in the motions, and there's a reference to numbers that lay out the parcels. There's also an exhibit attached to the final judgment that identifies all the parcels that are subject to the final judgment.
But didn't even Tony Roma say that customary use doesn't impact the interest in a property? So it's not really a claim against the property, correct? At least according to the Florida Supreme Court?
That's correct, and that's why we didn't file this pendants, because we didn't see that we had a property right at issue. It was more of a,
Don't normally landowners have the right to exclude others from their property?
not if it's not in their bundle of rights or their bundle of sticks. And the concept of, we submit the concept of customary use is if customary use precedes your ownership, then you don't have the right to exclude the customary's historical continuous use for recreational purposes of the dry sand. And so you don't have that right to exclude. So there can't be a taking of something you never had in the first place. In this instance.
Why not couldn't you do a class action instead? I mean, couldn't the county just have a class certified of all the properties in beachfront property in the county? I mean, there is a civil rule vehicle already to deal with the numerosity, I mean, you know the standard for.
Judge, you're absolutely right. We looked at that, and then we looked at doing a class action. We looked at naming all the property owners, and every time we looked at something other than what we did, it was how do we reconcile the provision in the statute that states that essentially the property owner has the right to decide whether he or she is going to be a party. And so we looked at the statutory framework that allowed a property owner to decide, do they want to be a defendant, rather than giving the county the right to say, we're going to make you all defendants, even though the statute says you have the discretion to make that decision. So that's why we didn't do a class action. That's why we didn't name all the folks. We followed the letter of the statute strictly, and that's how this thing started.
What's the status of this? Like, what would you do with this judgment? You call it judgment now.
The next step is a discretionary step of the county. They had to jump through the hoop to get a determination that customary use has been affirmed on certain parcels, and that's what this final judgment does. If the county desires to adopt another customary use ordinance, and they're not obligated to do so, and they haven't done so, they have met the predicate that 163035 required them to meet. Now, that's gone. So we don't even need that judicial
That's
determination.
right. You don't need it. So my question is, well, so you have this, let's say we affirm. You have this judgment in hand. What do you do with it?
Well, we may end up using it, I'm guessing here, sir.
I mean, the end of the judgment, curiously, says for which let execution issue. Like, what would that be? Like, what writ do you get on this kind of order to execute?
I don't think you get a writ. I think this was a,
So there's no writ.
No
Is
writ.
there any supplemental relief that you could seek under the Declaratory Judgment Act
I don't see
on
it.
this one?
I don't see a writ, I see this as, again, it was created by the
enforceable?
legislature. It was it was a box we had to check.
Right.
If we didn't prevail with our evidentiary basis for the four-prong test, we could not go, just, don't pass go. We could not go to the adopt an ordinance stage. Under that framework, we had to do that first step. We've done that first step. That first step doesn't matter anymore. As I said, we're back to pre-2018, where we have home rule authority. We don't need to comply with a statutory process. And the county, if they decide that they want to regulate customary use on the beaches, they have that discretion.
Does this judgment change the county's relationship with these particular property owners in some way? Alter the rights between each other, between the county and them?
To a certain extent, yes, sir. The judge incorporated based upon stipulations by the parties. And let me back up for 1 second, sir. There were parties that were disputing the county's efforts to establish customary use in this case. And as part of an agreement, the county dismissed anybody who was disputing customary use. And we limited the county's motions to folks who never moved to intervene, who never appeared as a party. And part of that agreement with the folks that were challenging it, and they entered into settlement agreements and dismissals, were certain restrictions on the customary use rights that would be contained in the final judgment. And you'll see a laundry list of when can the public use the beach for sunbathing, where can they walk, what are the hours of operation, what's the transitory zone, it's a 20-foot wide section of the beach. If the homeowner wants to use their beach and there's a member of the public on his or her beach, the homeowner has priority and can tell the beach user to get off my property. I want to put my blanket or my chair down there today. So there was a framework that was negotiated with opposing counsel that were representing hundreds of property owners. And that's, to the extent you asked, has something altered as a result of this decision? I would say yes, there's limitations on what the county agreed to put on itself if it proceeds with a customary use ordinance, and those limitations are spelled out in the final judgment. I do want to touch upon, if this court were to agree with the petitioners that somehow they are properly before you, even though they had an adequate remedy below that they did not exercise, and this court decides to quash the final judgment, we would respectfully submit that there would be two components to that. If you went there, we're not suggesting we want you to go there, but if you go there over our argument, one, we would respectfully submit that such a remand and quash would be limited to only the three petitioners. Your jurisdiction, this court's jurisdiction, was brought by three petitioners, and they didn't bring it on behalf of the other 80 or 77 property owners. We submit that it would be finality for the other property owners who did not seek appellate review, whether through a notice of appeal or through certiorari. There's only three folks, and they're the three that are before you today. And secondly, if this court were to quash and remand, we would suggest that we did have two components to our complaint, because this was a new beast, 163035. We had never seen anything like it before. So we had a prayer for relief based upon Chapter 86, and we combined it with 163035. It was kind of a belt and suspender approach, but the Chapter 86 is still a valid cause of action. If this court were to remand, this is at the summary judgment stage, we didn't have a trial below, and that we would seek leave to amend our complaint, proceed with Chapter 86, and name whatever parties that we decide want to put on the other side of the V. And it would be limited to the pool of parties that were subject to this final judgment. We're not.
But so you can see then that in the case of a deck action, you would need defendants on the other side of the V, correct?
If this
the
was a
only
pure-
reason you
I'm
didn't
sorry.
have it in this case is because you were, abiding by the statutory procedures. that have now been repealed, correct?
Yes, ma'am. If this was a pure deck action, we would have said Walton County versus Tom Jones and just list them out. But because it was a 163035, which we deemed to be our primary cause of action, and as I said, the statutory provision said that the property owners decide whether they're parties. That's how we ended up with.
And you can see, I guess, the struggle we're having with, when you do have the parties on the other side of the V, that's a proper invocation of judicial power, right? And the other way, which again is now repealed, seems more executive or legislative as opposed to judicial. But again, and it kind of goes back to what harm is left for us to remedy at this point, since the procedure, the judgment we have in place was as a result of a process that's no longer appropriate or on the books.
That's absolutely correct. So,
What is, so ask the same question to you that I asked opposing counsel. Had the legislature drafted this now repealed statute in such a way that it had an executive agency make a certification about customer use, that, you know, you can use your experts internally and do investigation, make whatever determinations you need to make, and then certify whether there's customer use here, and then issue, you know, an agency order in some way, and that's the condition precedent for your ordinance for going into effect. Could the legislature have done that?
I could see a framework under Chapter 120 if you had, like, if we used the Department of Commerce, that used to be Community Affairs, and said that they would enter some type of order that's subject to review, administrative proceeding under Chapter 120. I think the legislature could do that.
So if they could do that,
I think
then
so.
how could they have a court do the same thing and not be violative of Article 2, Section 3? Basically, such so that, you know, how could, if the executive branch could do that, an administrative agency could do that, then could a court exercise that same authority, that administrative authority, to make a certification? as a condition
I'm sorry, I
precedent?
thought you were done,
Yeah,
sir.
That's
Apologize.
a question.
I don't see this as an administrative action that the trial court took. This was hotly contested judicial proceeding. We had over 500 defendants involved. We had 45 lawyers involved, hundreds of depositions. Just
All fighting
Well, how's that different from DOA, other than Judge Green was sitting there rather than an ALJ?
You're right, it's the
Okay.
same judicial process, even though DOA is kind of quasi-judicial. But the legislature created the cause of action, just like they created Chapter 86. So I think the legislature has the legal authority to say, here's your framework. We don't like a local government doing this, which is making a determination of who's subject to customary use. It was Senator Pasadoma was basically stating, we want a judge making these determinations before a local government imposes customary use or regulates customary use. So that's how we ended up with the legislature creating the cause of action.
But that statement alone kind of tells you there's something wrong, because we want a judge to make what is essentially an administrative determination, that most of the time you see an agency making that determination. But in this instance, we want a judge because, I guess, people like us more, or trust us more. We want a judge to make that same decision. That's not typically what judges do. I mean, the judicial power is usually to resolve disputes between parties.
And I think we clearly had a huge dispute between parties by the 500 folks that opposed customary use, not wanting the general public to use the dry sand. And the
But they're
case,
ultimately arguing over an abstract question about customary use. They're not arguing over their individual right as against, you're not proceeding against them directly. You're saying, you raised in the complaint, you raised this general question about customary use and invited people to come in if they wanted to dispute that question. As it turns out, it's in a courtroom as opposed to a DOA room. But what's the difference?
it was more than just a general question. It was specific parcels with specific evidence, identifying properties that were used historically. We went back to aerial photography to look at over the generations on how the dirt had been used. I mean, this was a highly individualized analysis for the parcels that were part of our complaint. And you know, even though at times we disagreed with Judge Green's decisions, he did an outstanding job herding these cats and putting together what he ultimately did was just an amazing amount of data and corralling 45 lawyers. I thought Judge Green did an excellent job, and it required a judge with his talent to pull it off, with all due respect to Judge Green. And I'm out of time in 19 seconds. Actually, I'm over. If there's anything else, if not, we would request that you affirm our final judgment. Thank you.
Thank you, Your Honors. We've agreed to split the remainder of the rebuttal in half, so I will do my best there. I'm just going to briefly run through what we just heard. In terms of standing on appeal, Judge Tannenbaum, the court did convert this appeal to a certiorari. That said, the focused order did mention appeal, but I don't take that to mean that the decision's been reversed to convert it back to a plenary appeal. Of course, we've made an argument in the brief. I understand the court's rejected that argument about why there's an exception to the party standing appellate doctrine. That said, the procedure for intervention under 163.035 is not an adequate remedy that would preclude certiorari here, because that never cured the subject matter jurisdiction defect from the very beginning.
Go to, with the limited time that you have, unless someone else wants to hear about jurisdiction, can you address how is it that this order, whatever it is resulting in a miscarriage of justice or in some way causing significant harm to your clients? Based on everything you've heard.
On the irreparable, well, I appreciate the county's representation that the 2017 ordinance is invalid or remains invalid. But what I'm hearing is there could be collateral legal consequences if this judgment's allowed to stand, if it's not reversed, because it sounds like the county may be utilizing the fact findings of customary use that are here to issue another ordinance just like the 2017.
Do you think there could be a basis for a collateral estoppel on this kind of order?
Well, I think if we don't correct the subject matter jurisdiction problem now, I would expect to see that argument, I suppose, on the other side, that this has been resolved, these facts have been found by a court that, for all intents and purposes, looks like it had jurisdiction at the time until somebody comes around and explains that they didn't. So I do think that this finding, and I'm looking at page 20 of the final judgment, the public may use the area of the beach. I mean, that is the harmful statement, because that, like we've said with our anecdotes, the sheriff won't enforce our trespass rights if that's what the final judgment says.
Is it sufficient harm to support cert for, I guess, even though it might be a nullity, to parade around as if it has the imprimatur of the judiciary? What are you supposed to do with this order that is nothing, perhaps, but no one else knows, and you don't have any official saying that, yeah, it has the court caption at the top and it's signed by a judge, but it doesn't mean anything?
I've been thinking about
sufficient harm?
I think it is. I think it's sort of like a wild deed, Your Honor. I'm trying to think of the best analogy for it, but it's something in the record chain of title that purports to strip away a right that shouldn't be allowed to happen.
Because it's recorded and it's causing...
Yes, Your Honor. And I'll yield the remainder of my time. Thank you very much.
And you're going to have a hard time convincing that deputy sheriff that there was never jurisdiction for anything in this order, so you don't have to worry about it, right?
Absolutely,
And here's my
Your Honor.
brief. You can read it.
They won't even enforce one's orders on our side sometimes. So anyhow, with respect to the miscarriage of justice, let's go back to the right to exclude, Your Honor. The United States Supreme Court has said the right to exclude is one of the most treasured rights of property ownership. The right to exclude is universally held to be a fundamental element of property right and is one of the most essential sticks in the bundle of rights that are commonly
No, but when you
characterized
acquire
as
property, you only acquire the sticks in existence. So if a right in property had been released somehow, or there was an easement. You don't have that anymore, correct?
That's correct. And that takes us back to the Lucas case where the county's saying, well, it never existed. Well, what have they pointed to say it's never existed? Well, we got fee simple title from the federal government. They had a whole bundle of sticks in that rights, and that's transferred all the way down. There's nothing in that chain of title.
Well, they're saying
losing
even
it.
before there was a federal government, there were people out on the beach barbecuing,
there's-
playing cornhole or doing whatever they do out there.
Well, there's got to be a law that says that right to exclude never existed. And there is no such law. They're relying on this doctrine of customary use that the Florida Supreme Court created in dicta in 1974 that we say is not substantive law. Because the only way to have, the right to exclude not be part of it, it's got to not exist somewhere. And they looked back at England, and in England, the doctrine of customary use applied when the use went back to time immemorial. Well, the Florida Supreme Court created a brand-new doctrine here. Brand-new doctrine said, it's ancient. It's not time immemorial. It's ancient. What is ancient? We don't know. And so in this case, they created something new. And the Lucas case says you don't have rights, or you don't have a right to a taking if they didn't adhere in your title. And with respect to that, they said any newly decreed law that takes that right is a taking. And the Florida Supreme Court did that in 1974. They newly decreed a law that took the right to exclude. Thank you. And we would ask that you vacate the judgment as to all 83 properties with respect to the customary use. Thank you.
All right, we'd like to thank counsel for their briefs and their oral argument, and we are adjourned.
All rise.
Thank you, sir.
Good day now.
Thank you so much, you too.
Guess we'll see you on next round. Is that right?
I'm sure we'll be back to number 4 sooner or later. Thank you, Mr. Marshall.
Y'all be good.